Yeah. Yes. Yeah. Okay. Where do you want us to start? Yeah. Thank you. Thank you very much. A very good afternoon, honorable members of the press. With me is the principal judge of the High Court, the principal judge of the Courts of Equal Status, the Honorable Mr. Justice Oscar Angote, Honorable Justice Ongaya, and the commissioners of the Judicial Service Commission, Commissioner Mwansa, Commissioner Evelyn Orwande, and of course the Chief Registrar of the Judiciary. We are here to issue a statement on the intimidation and withdrawal of the security detail of Honorable Mr. Justice Lawrence Mugambi. The Judicial Service Commission has convened this press briefing, of course flanked also by members of the judiciary, to address a matter of grave concern, an action that not only undermines judicial independence, but also threatens the core principles of the rule of law and constitutionalism in our country. As it's now publicly known, Mr. Justice Lawrence Mugambi, a judge of the High Court, has been presiding over a case brought to court by the Law Society of Kenya and 3 others against the Inspector General of Police and 4 others, which is petition number E436 of 2024. That case was filed in court following allegations of abduction or arrests of 3 individuals, Bob Mesheni Njage, Jamil Longton, and Saram Longton, who were allegedly abducted or arrested on the 19th of August 2024. This led to filing of a petition number E436 of 2024 before the Constitutional and Human Rights Division of the High Court, seeking an order to compel the authorities to produce the missing individuals. Honorable Justice Mugambi, presiding over the case, issued what we call habeas corpus order, directing patent in contempt of court proceedings, where the acting Inspector General was subsequently found in contempt and sentenced on the 13th of September 2024. In the wake of this ruling, a disturbing action was taken by the National Police Service over the weekend. The security detail assigned to Honorable Justice Mugambi were disarmed and withdrawn. This deliberate and punitive measure represents a direct assault on judicial independence, an affront to the rule of law, and a violation of the principles enshrined in our Constitution. Article 160 of the Constitution unequivocally protects judicial independence, stating that the judiciary is subject only to the Constitution and the law and shall not be subject to the control or direction of any person or authority. Additionally, any benefits or conditions of service related to a judge's position, including their security, must not be varied to their disadvantage, particularly in retaliation for the lawful execution of their judicial duties. Security for judges is an accrued benefit that cannot be withdrawn whimsically. The act of withdrawing the security of a sitting judge following a judicial decision that displeased certain authorities is deeply concerning. It sends a chilling message to the judiciary and indeed to the public at large, that those entrusted with upholding justice and safeguarding our rights can be intimidated, that judges can be bullied or retaliated against for their rulings. Such actions erode public trust in the independence of the courts. They also undermine the very foundation of our constitutional democracy and pose a risk to disregard of our institutions and descends to lawlessness. If dissatisfied with a judicial decision, the appropriate recourse is to appeal to a higher court. Indeed, we are aware that an appeal has already been filed and is waiting to be heard and determined. We caution, however, that retaliatory measures against a judge or judicial officers have no place